So is the J.P. Morgan London whale the right instance for the SEC to be making this a test case? Attorney Mark Lopresti is with me. He says the SEC is being ridiculous. But Andrew Stoltmann of the Stoltmann Law Offices is behind Mary Jo White all the way. Gentlemen, good to have you on the program. Thanks very much. You know, it's interesting, Mark. She said if it's egregious enough, you know, if there's widespread fraud. When you look at the London whale, you think of stupidity. You think of a trading mistake with their own money, but fraud?
Right. And that's what's troubling.
Yeah.
And I think the point that I'm trying to make here is that the SEC should be looking to punish more of the bad actors and not just the corporate entities, because at the end of the day, it's the shareholders that are going to suffer the pain of a multi-million-dollar or $100 million fine in this case. And as was just very important to point out, in a situation like this where they are going to require, as is the new policy, an admission of liability, that is going to open the floodgates potentially to civil litigation on this very matter that would not have otherwise occurred had this new policy not been enforced.
That's absolutely right, and that's probably the most important point here, Andrew Stoltmann, because once J.P. Morgan says, yes, we admit wrongdoing in the London whale trading case, that opens the floodgates, as you just heard from Mark, in terms of further lawsuits. Why would they do that when we all know that this was a stupid mistake, but it wasn't necessarily, and we know that it was not fraud? So why would they admit wrongdoing? Why are you so in favor of this?
Well, look, Maria, I mean, the employees are the corporation, and I'm sorry if the corporation is going to have to spend money with respect to civil lawsuits, but you lost $6 billion of shareholder money. And yes, it's unfortunate that you may have to admit to liability, but guess what? This is the SEC's new policy, and if J.P. Morgan doesn't like it, then go to trial on it. But I guarantee you they're not going to do that because they know they screwed up. They had lax supervision, the supervisors weren't paying attention, and when that happens and you lose $6 billion of shareholder money, you got to pay. And one of the ways you now pay is through an admission of guilt.
Yeah, the problem I have with that, though, Andrew, is that how can we be concerned about the loss of the shareholder money on the prop trade, but not on the loss of the shareholder money that's going to result from the fines and the tens of millions of dollars of legal fees that the firm is going to have to spend? What I'm saying here is let's go after the actors. Where is the individual liability? That's what Main Street's looking for. We haven't had that.
Look, you can do both. You can go after the traders, but you can also go after the firm and make them pay the fine. And guess what? If you do that, and if you make the firm have to pay it, then that will hopefully have a prophylactic deterrent impact going forward. It's just sound policy to not let firms and banks hide behind the legal charade of, gee, we're going to pay all this money, but we didn't do anything wrong. Of course you did something wrong. That's why you're paying the money, and I think it's a good policy. I'm ecstatic to see finally the SEC is making this common sense evaluation and making firms admit to guilt.
But even with the $6 billion trading loss, J.P. Morgan had a record year. They had a record quarter. They're making money for the shareholders. The stock is
Maria,
up. So who cares?
Well,
You're talking about the shareholder impact. So am I.
But
shareholders care.
But if you also lost $6 billion, the simple fact that you also made the company money in other divisions, it doesn't mean that we can just say, hey, fine, the company's profitable, let's sweep this under the rug. That's $6 billion of shareholder money that you lost because you had shoddy, bad internal controls, and I think that's problematic.
But you know how investing works. If you make a trade, you could win or you could lose.
Yeah,
and if you
Maria,
have proprietary trading, why is it different?
But Maria, this is different because this trade went under the radar. The size of it went under the radar. The supervisors didn't know it was taking place. And then when it finally comes out, we get the old, gee, it's just a tempest in a teapot. Guess what? It's not. This is very serious conduct. There have been brokerage firms that have suffered catastrophically big losses because supervision and compliance department wasn't paying attention. And that's the problem I have.
Let me be clear on one thing where I, of course, do agree with Andrew. Failure to supervise and supervisory procedures on the street need to be enforced, no question. What I think is glaring here is that we are not seeing individual accountability. What we are seeing is further pain imposed on the shareholders and on the markets. What we are seeing is a continued lack of the ability of the SEC or the DOJ to say, wait a minute, XYZ, John Smith is responsible for doing this or that. It's very reminiscent, if I may, Maria, of the SEC's decision to pursue a failure to supervise claim against Stephen A. Cohen just a week and a half or 2 weeks ago.
Yeah, right.
It's very illustrative of what's going on
here. Well, let's talk about that, because there was news yesterday that the firm will be operating while this goes on, and what's your take on that?
Well, my take on that is that that's actually an incredibly good thing, and it's something that represents a bit of a departure from how the SEC has sometimes handled these matters. In the past, shareholders, investors, firms, funds have suffered where receiverships have been put in. Very quickly, emergency TROs have been applied, in many instances for the right reasons. I think allowing SAC to continue in the ordinary course while it defends the charges was the right move. But what I think is the real question here is, where is the evidence linking individual liability? Why has the DOJ and the SEC not been able to pin or to bring these charges against an individual directly?
Okay, but by the way, on the J.P. Morgan story, Andrew and Mark, real quick, several people lost their jobs over the London trading whale. Is that not accountability?
That's not enough, Maria. I mean,
that's not enough? It's not enough that several people have lost their jobs at J.P. Morgan?
Absolutely not.
So who are you looking to target here? You talking about the chairman and CEO?
Well, look, I've long thought there have been other chairmen and CEOs of brokerage firms who have suffered these sorts of losses have been forced to leave. I think the firm has to pay a fine. I think it has to admit to guilt. And, there's still a criminal investigation going on by the FBI and DOJ. So let's see how that plays out. And it's possible criminal charges might be necessary.
All right, we got to jump on this. This is a story that needs to be discussed further. Gentlemen, come back soon. Thanks very much for your time.
Thanks, Maria.
Appreciate it.